And tomorrow, the U.S. Supreme Court will hear arguments in a landmark case brought by 6 Colorado voters. They allege former President Donald Trump engaged in an insurrection. Your political specialist, Sean Boyd, has followed that case since it was filed. Sean breaks down how we got to this point and why this case made it further than similar challenges in other states.
Security is tight here outside the nation's highest court, where police have set up barricades in anticipation of a large crowd. The high-stakes hearing is the culmination of a long-shot effort to keep former President Trump off the 2024 ballot. It all started 3 years ago when a law professor posted research about a little-known clause in the Constitution addressing insurrectionists. A Washington-based group would use that clause to remove a county commissioner from office after he participated in the January 6 attack on the Capitol. Emboldened by that win, the group set its sights on Trump and identified Colorado as the perfect state to make a stand. On September 6, 2023, Crew filed a lawsuit in Denver District Court on behalf of 6 Coloradans, 4 Republicans and 2 unaffiliated voters, asking a judge to bar the Secretary of State from placing Donald Trump's name on the primary ballot, saying he violated Section 3 of the 14th Amendment. Written more than 150 years ago to prevent Confederates from holding office after the Civil War, the constitutional provision says any officer of the United States who engages in an insurrection after taking an oath to uphold the Constitution can't hold office again. But not every state allows voters to challenge a candidate's eligibility. Colorado not only allows it, it requires an expedited ruling and sends appeals directly to the state Supreme Court. Plaintiff's attorney Mario Nicholas says a fast-track process was critical with the Iowa caucuses just 4 months away at the time.
A resolution sooner rather than later is important, and if this had been another state where you had other layers in there, it might not have happened fast enough.
The unprecedented trial in Denver District Court lasted 5 days and included more than a dozen witnesses. Plaintiffs argued Trump used inflammatory rhetoric to deliberately goad his supporters into engaging in an insurrection, then watch for hours as the chaos unfolded. Trump's attorney, former Secretary of State Scott Gessler, insisted speech or lack of speech is not engaging in an insurrection.
He acknowledged that people would be marching to the Capitol, and he urged them to go peacefully and patriotically. And that was the overriding theme of his messages that day.
The judge delivered a split verdict saying Trump engaged in an insurrection, but Section 3 doesn't cover the president. Nicholas says she's wrong.
Look, at the time it was drafted and it was ratified, everyone understood this to include the president.
In fact, it was an initial draft that specifically applied to the president and vice president. And Congress, when they continued to debate it, removed the presidency and vice presidency as offices.
The case was appealed to the state Supreme Court, where Gessler argued the lower court got it partially right, saying Section 3 not only doesn't apply to the president, only Congress, not the courts, can enforce it.
So if we're going to do this, we need to do it on a fair and an equal basis across the country, and it's Congress that sets up that standard. You don't want this crazy patchwork of states, each state going off and doing its own thing.
2 weeks later, in a stunning 4-3 ruling, the state Supreme Court overturned the district judge's ruling, but suspended its judgment pending an appeal to the U.S. Supreme Court, where 3 of the justices were nominated by Trump. Nicholas is still optimistic.
So much of our argument and so much of what we've done is based on originalism and textualism, which they claim that is their guiding star for all this.
While Trump's name will appear on Colorado's primary ballot, which had to be set the beginning of January, the U.S. Supreme Court ruling, which is expected before the March 5th primary, will determine whether votes for the former president count. While petitioners are asking the court to keep Trump off Colorado's ballot if they are successful, other states are sure to follow Colorado's lead. The more states that do, the fewer delegates Trump will get, and the better petitioners' chances of preventing him from returning to the White House. Both sides tell me they expect a ruling before March 5th, Super Tuesday, when 15 states, including Colorado, will hold their primaries. at the U.S. Supreme Court. Sean Boyd covering Colorado First.